show you the panoply of existing documents. There is one general model grant agreement. It's this big text, which you all know, I guess, more or less. And there are some derived models. But these derived models are different only on some aspects. So really the bulk of the articles and all the stipulations is very much the same in all models. So we have the derived models for the ERC, for the new SME instrument, for the Marie, order of category actions, and for the so-called co-fund actions. This is the zoo of existing things. Compared to FP7, the structure of this legal document has changed. In FP7, we had a core text with articles, then we had an annex with general conditions, we had special clauses and other specific provisions. This is now all integrated in the articles. So these annexes do not exist anymore. Special clauses are handled by way of options in the respective articles. So our lawyers say that this is more standard in terms of the legal drafting, and for the lawyers it is easier to understand. Up to you to decide. That is the structure of the new draft agreement. It has 7 chapters. It starts with the general chapter, which is basically describing what it's all about. Chapter 2 describes the action and duration of the budget. Chapter 3 speaks about the money that we intend to give to this project. Chapter 4 specifies rights and obligations from both sides, of course. Chapter 5 describes who is responsible for what: commission, coordinator, consortium, partners, internal arrangements. Chapter 6 is obviously the nasty part, where it's about rejection, reduction, penalties, termination. So hopefully you will never be concerned by Chapter 6, and Chapter 7 is just entry into force and applicable law things. Still, there are some annexes. Of course, the main annex is this description of the project itself. It's this so-called Annex 1. And then there are the budget tables, Annex 2. Then there are the so-called accession forms, which are not so really valid anymore now, because in the electronic system, the partners in practice just sign the whole grant agreement as the coordinator. But still they are there, and they are just the placeholders for the signature of the other partners. Then there is a model template for the financial statements that you have to send with each periodic report. You have, at the end of the project, you have to send certificates on the financial statements. So you have to ask your auditor to certify your costs. But this was in FP7 several times in the project if your amount was big enough. Now this is only once at the end, so you have fewer certificates to provide. And then there is an optional Annex 6. You can also in Horizon 2020 ask ex ante that your method for calculating the average personal cost is certified ex ante if you want, but you don't have to. And here we have the template for this.
The certificate on financial statement, is it ready to move from subcontracting to direct cost development? Yeah. I don't.
Yes, I think so. But as I said, there are much fewer.
Yeah.
Wait, did you say that only at the end of the...
Only one at the end, and only if the amount to you is higher than 325,000.
During the period there is newly 325, there's no...
No. You only need one at the end if you exceed these 300.
So for example, in the ERC where you want to spend 500,000.
Even in the ERC, only at the end. Only at the end.
Why is this called annex to the grant? It's not an annex to the grant, if I understand what you said before.
These are templates. It's,
Ah,
so
just
the
the-
certificate
just
is a
the empty
template.
template.
It's just saying if you want to do this, this is the
Okay.
model for doing it. So this you all know. We have this matrix of reimbursement rates in FP7. Now we have the principal one project on reimbursement rate. It's 100% in normal research actions, and it's 70% by default in the so-called innovation actions. With one exception, you also know non-profit organizations get, even in these innovation actions, get 100%. So I guess the universities would be classified as 100%. We have different methods for charging costs, and they are now made very clear in this grant agreement. We call them the forms of costs, with actual costs, unit costs, lump sums, and flat rates. So this is the way you can charge eligible costs. The standard is, of course, as it was in the past, the actual cost. That means you incur costs, you get an invoice, you pay a gross salary. This is in your account, and this is an actual cost item. You charge it to the project, and this is the standard which was also used in 2020. A new item here: if the VAT that you have to pay, you cannot recover it from the state, this becomes eligible cost in Horizon 2020. But it's really only for the non-deductible. So then there is another possibility, if provided for in the legal basis, that you can charge unit costs. Unit costs mean you have defined, or the legal basis has defined, the nature of the unit and the amount per unit. One example here is the so-called SME owner-manager unit cost for SME owners not paying themselves a salary. In this case, the unit is the hour work, and the amount per unit is a predefined number, which you find in our documentation. And so what you have to charge is the number of hours. So you say this SME owner has worked 275 hours on the project. That is all you have to provide, all you have to document, and all that our auditors exposed can check. So when they come to this SME who has used this methodology, they cannot go back and check the actual costs behind it. They can only check that he has actually worked 275 hours on the project. So this is, for all these three other forms of cost, that is the very principle. You will never come back when you use unit cost, lump sum, flat rate, and check the actual costs behind these special forms. And that is also one sort of simplification potential behind these things. Yeah.
But the number of units, in the case of unit cost.
Yes.
So actually you determine the number of units at the stage of budget preparation, say.
You estimate. Yes.
You estimate the number of units.
Yes.
And then you may have a bias, say, from this, but not of the cost per unit.
Not of the cost, because the cost for the SME owners, so it's used for the SME owners, and it's used very heavily as a basic principle in all the Marie Curie actions. So in the Marie Curie actions, the unit is the researcher month, and there is a table saying how much the researcher month is worth. What we will check exposed is only that these researchers have actually worked for these months in the organization. We will not come back and check whether this overhead amount was actually spent, or whether there was an allowance for this or that was actually incurred. We only check that this, so to say, the driver of the cost, the generating event has taken place.
Just one other question. In the innovation action, you mentioned the 70 versus the 100.
Yes.
The only exception are the not-for-profits.
Yes.
And SME is not an exception.
No. SME is not an exception. SMEs get 70%.
What method of proof is used to validate the researcher hours?
We come to this. You have to, in normal circumstances, for many of the people, you have to have timesheets. So you have to record the hours worked on the project.
So whereas previously in some industry,
We come to it, there we have a special slide. Okay, so we covered the unit cost. Lump sum is even easier, because there we say there is a generating event, and if this event has taken place, the lump sum is accepted. The example currently used is the phase 1 of the SME instrument. So there we have a lump sum of 50,000 euro for a whole project. And so there are only two situations. Either the project is implemented and the deliverable is accepted and the 50,000 are paid, or the project is not implemented and the 50,000 are not paid. That is, and we will not go back and check any costs that have been incurred in relation to this project. We only check the delivery. That is true. And the last thing, flat rate, that is an easy one. It is a percentage which is calculated on the basis of some other costs. Of course, the main example here are the indirect costs. So we pay 25%, supposed to cover the indirect costs, 25% on the eligible direct costs. And again, we will never come back and go into your accounting system and check what real indirect costs you actually have. This is covered by this. So for the indirect costs, you know, we have this complicated system in FP7 now, we have this single flat rate. In this table, you also see that the actual costs are still the main mode of implementation. So you here have these forms, and here you have budget categories, and you also see that many of the options are actually not available. So actual costs are available everywhere. So for personnel, for subcontracting, for other costs, and so on. Actual costs are not available anymore for indirect costs, and then there are some specifics. Unit costs are basically there for the personnel, means SME owners, or you use your organization-specific scales, which is called the average personnel cost. It's also a form of unit cost. And unit costs are available in some special actions where they are predefined in the work program. So for instance, there is a system of unit costs for clinical trials in the health program, where you can charge the cost of clinical trials not on the basis of actual costs, but on the basis of scales of unit. These scales of unit are defined by project. But there is a methodology on how you can build these scales of unit for the health projects.
They didn't put also Marie Curie.
Yes, because these slides are on the general one. So Marie Curie, of course, Marie Curie would also appear here. It's also unit costs. But in Marie Curie, unit costs cover not only personnel, they also cover a part of this coordinating and management. So it's very special. Flat rate costs we currently have only for the indirect costs, and lump sum costs we currently have only for the SME phase 1 instrument. Plus, there is a special type of coordination and support action in one particular call, which I have not covered, but you will see it in the workflow. So that means you are not completely free in choosing which forms of costs you use. The standard is the actual cost, and then if...
And the average personnel is only if you have a certificate of methodology?
No.
No.
So average personnel cost is if in your organization you use such a method, so with categories of personnel, then you can charge it. You need to have a methodology. You can ask for an ex-ante certification, but you don't have to. But there is, of course, a high risk that you use this methodology and we come back afterwards with an audit, and we might have some criticism to your methodology. So if you want to be on the safe side, you ask for this ex-ante certification.
Excuse me.
Yes.
In the past, it was quite easy to download a guide for proposals. Then it became, for some reason, more and more difficult. You had to be inside after a project to download something like this. Is there any easy way to, if you foresee the kind of project you are thinking about, to download this document and clarify these questions at a specific level?
We don't have guide for applicants for each call anymore because it became unmanageable. Because these were call specific, and so we had millions of documents to manage. What we recommend is that if you want to know the general description, you go in this online manual where you find already a lot of things. So there is a part on preparation and submission of proposals. There you find already a lot of things. And then when you are interested in a specific topic in a specific call, you go into the respective topic page where you find a collection of all the information.
And it's included there? It is included
There is not one downloadable PDF document.
No, but specific.
But the information is there, yes. The specific information is there. I don't know if our system is back to, let's see. Apparently not. No. Any more questions on these costs? No. Okay. What about the flexibility to change within the ongoing project? So there are some moves in these budget tables that are allowed by default, some of them that are forbidden by default, and some of them where you better ask in advance. So the green ones, it's not really green here, but it should be green, are allowed. The red ones are not allowed, and the yellow ones you ask in advance. Maybe I'll focus on the ones that are not allowed. So you cannot change between forms of costs if in one of the forms there was nothing before. For instance, you have personnel costs where you have estimated 500,000 actual costs. And then you suddenly want to use a unit cost method for personnel costs. That is not possible. So you should have provided in advance for the possibility of charging, for instance, average personnel costs. On the other hand, when you want to change and transfer some cost items from one beneficiary to the other, no problem, you can do this. So, for instance, one beneficiary was supposed to do something, and now you decide that it's better that the other one does it. The related costs you can shift to the other beneficiary. Of course, with these
The other one agreed.
Of course, you have to agree inside your consortium. But as a matter of principle, from our side, this is allowed.
So excuse me. So, where you said that it's not possible to transfer, is there any rule regarding the percentage modification?
No.
So it's a good rule to put €1, say, for everything, and you buy the right to transfer.
Yes.
Okay.
No zeros allowed.
No zeros. There is a special case which is the subcontracting, which you are supposed normally to specify in the technical descriptions. You should say what part of the project you want to subcontract. We have now some flexibility of accepting changes with the periodic reporting, but still the recommendation is if you want, so first recommendation is identify all your intentions of subcontracting in the technical annex already in advance. And if you really want to switch subcontract from one beneficiary to another one, ask in advance. And probably it's better to prepare an amendment to be on the safe side. Because when you do it just like this and you then report on it, and then your project officer says, no, I don't like this, then you have, so the commission has the right to be flexible, but not the obligation.
If you have a situation that a beneficiary does the research with a link company, and the link company is not in the project, right? The link company has the cost. How do you, and it's not subcontracting because it's a link company.
Yeah.
So how do you deal with it?
Yes, there is a slide on this. Link third parties. So
okay.
Come to it. Yeah. This is again the same. What you can do without amendment. So the no's you mean you can do it without amendment. If you want to reallocate actually tasks from one party to another or rewrite the whole technical annex, you need an amendment. And then if you want to transfer between unit costs, and actually you need an amendment. And for the new subcontracts or changing of subcontracts, it's strongly advised to still have an amendment.
But if you write yes, strongly advised, it means that you're not obliged.
You are not obliged, you can take the risk, you just do it, you report it in the periodic report. The project officer looks at it and has a margin of decision.
It's not obliged.
In the past, in FP7, the project officer did not have any margin of decision, so he had to refuse it. So the cost for you would have been lost. Now, there is a possibility, of course, if you have a very good justification, you can convince the project officer, then you can go, but it's, as I say, it's certainly better to ask for it in advance.
The coordinator will ask?
Yeah, it's always the coordinator because that is our interlocutor. So then there is this notion of duration start date. The duration is always in months. You see it in the Article 3 of the grant agreement. And also the start date is defined in Article 3. It is always, I would say, the first day of a month. So it's the 1st of September, January, whatever. And the default option is the first day of the month following the entry into force. And the entry into force is once the coordinator and the commission have signed. You also have the possibility to agree on a fixed date, which can be later than that, or also earlier than that. But this is a matter of agreement with the project officer, and you need a justification if you want to go for this exception.
The exception is built on what, on which consideration?
The exception, if you have, for instance, projects that are linked to seasons of the year. So a research vessel having to go to the Arctic, and they can go only in summer. But the project starts in autumn, because the call was only at that moment. Then we can agree that a project starts already in summer, and we can, these costs can be become eligible. But it is on the risk of this consortium, because unless the project is signed, you have no legal certainty. So you incur all these costs on your own risk. Normally you are relatively sure that you will get the project. So the cases where once the evaluators have said the project is good and we start the project, the cases are very rare that we stop. But there is a certain risk.
May I correct you?
Yeah.
It's not because the project is good. Because the project is returned, because there are a lot of good projects which
Yeah.
are not returned.
Yes, like I said, the project is high enough on the rank list that the money is sufficient to okay, that's right, yes. Important correction. Okay, but also here there is no full flexibility. Of course, the project cannot have started before the proposal was even submitted. So the call deadline is the ultimate limit for the start. For the pre-financing, there is change compared to FP7. We pay very quickly now because it's all electronic. So also internally we have fully electronic workflows and very few people now involved. So that once the project is signed, the pre-financing comes quickly. But compared to FP7, the pre-financing is less. There is no strict rule on how much it is. We have internal rules which are mainly based on our shortage of payment credits, which is due to some inter-EU general problems with the EU budget. But as a matter of principle, you will still get, as a pre-financing, normally the estimated amount for the first report. So in FP7 it was very generous. You could get 70 or 80% of the whole thing as pre-financing. Now it's maybe it covers at least the estimated amount for the first report. And then there will of course be interim payments after you send in your periodic reports, and there we have a delay of 90 days for paying, and at the end we pay the final amount, which is now called in the new jargon of the lawyers of payment of the balance. Begin within 90 days of reception of the final report. In the same way as in FP7, we have the so-called participant guarantee fund. So of this pre-financing, we deduct immediately 5% of the overall amount and we put it on the bank account for creating interest to cover any risk of failing participants, people running to the Bahamas for money and so on. So we don't only have beneficiaries, we also have so-called third parties. And I think, Marcel, what you want to refer to are the linked third parties. They can be affiliated entities or parties with a so-called legal link, so where you have a really legally valid document saying that you have a permanent link between two organizations. That is very similar for the ones knowing FP7 to this clause 10 third parties. They must be identified in the grant agreement and they underlie the same cost eligibility criteria as the beneficiaries. So costs incurred by these linked third parties are fully eligible as for anybody else. We may request them to accept joint and sole liability for their new contribution, but this is only exceptional cases. In the budget tables for the grant agreement, the costs related to these linked third parties have to be specified in one separate row as for all the beneficiaries. So in the proposal, you might have seen you have to add up your own estimated costs together with the estimated costs of all your linked third parties and put this in one row. When it comes to the grant preparation, this has to be separated. There is one row for you, yourself as the beneficiary, and as many rows as necessary for all your linked third parties. And all the costs have to be specified in detail. And that is the same then when it comes to the sending of the financial statements. Also the third parties have to prepare separate financial statements. And there is another type of third parties which are the usual subcontractors. When you place subcontracts, you have to prove that you have done the necessary to ensure best value for money and to avoid conflict of interest. And as already said, the tasks for these subcontractors and the estimated costs must be specified in advance. And here, this exception, you might be a bit flexible, but still we recommend you to indicate in advance for the subcontractors. Best value for money doesn't mean you have to go through a full public tendering procedure. It depends on the circumstances. So it's a small subcontract for organizing a little conference in a hotel. You ask for 3 offers and then you take the best offer. But you cannot just give subcontracts to your friends or to all these people. You must show, you don't have to show it to us in your reporting, but you must have this evidence in your files, in your accounting system for the case that there will be an audit, and then you will have to justify that you have done efforts in order to ensure best value. Different from the subcontractors are the, so to say, services you use for the purchase of goods, works, or other little services. There the principle also applies, but these are, so to say, normal costs. Then we have so-called contributions in kind. So if somebody provides something to the project without asking for payment, these are the free of charge contributions in kind, and there are also this possibility to have contributions in kind against payment. They must again be set out in the technical descriptions of the project in advance. If not, the same applies as for subcontracts. We have a certain flexibility to accept them ex post, but better to do it in advance. Another new notion is the financial support to third parties. This is a very special thing which in all the normal projects doesn't even appear, but there are some kinds of projects where you have it, and if you can have it, it is specified in the grant, in the work program, and of course later on in your grant agreement. It is the case of the so-called cascading grants. So in some projects, you as the beneficiary are allowed to publish calls yourself and so to say give grants to other people, and then this is considered as an instance of financial support to third parties. It applies, for instance, to these ERANET projects. We also have the possibility to award grants for coordination and support actions for organizations organizing prize contests. And then, of course, part of this grant is the prize money, which is given by this prize organizer to the winners of the prizes. And it's also financial support to third parties. Again, these options are only if they are explicitly foreseen in the work program, and it's covered by Article 15. So for most of your projects, that will be not applied to. Next issue, personnel costs. This is, statistics show it covers in most projects 60, 70, even 80% of the project costs. And this is also the type of cost which is largely based on actual costs. That means here we have the largest vulnerability for any errors and for any findings in audits, and then for the pain of recovering the money from them. So it's a field where a lot of care is necessary to do things right. We have decreased somehow the requirements for the time recording. In FP7, basically anyone involved in the project has to do detailed time recording. Now we don't need time recording anymore for staff assigned 100% of the project. For this stuff, you only need a declaration saying, yes, that staff member worked to 100% of the project, and then 100% of the personnel costs for the person to be charged. If people work partially on the project, partially on other things, you need time recording. But you need time recording only for the part people have worked on the project. So you don't need any more full-time of all the activities of the person. So the minimum is that you just record the hours that the person has worked in the project. And you should, of course, do this regularly. So you cannot do it at the end of the project or 5 minutes before the auditor enters your door. It must be done real time. So at least once a week, let's say. There are templates available for, so to say, best practice how to do this. You don't have to follow this, but you should at least, with your own system, comply with these minimum standards. Yes. Yes.
You mean exclusively on the project within the organization?
Within the organization.
Which I mean, by which I am thinking, for example, that you hire somebody, a student,
Yes.
from the outside, and he works, say, 10 hours a week in the project, and that's all what he does in the university.
Yes.
So
you should have an employment contract saying this person works 10 hours per week, and then you should have either even in this employment contract already or in another agreement saying this 10 hours per week are dedicated 100% to this video project.
So no additional reporting.
But if the student at the same time has another employment contract with the university saying you work to giving undergraduates some courses, and that's not allowed. So it's really.
And if he has another 10 hours in another project, in another institution, for FP?
If it's a different organization, that is fine. So it's really useful, if I understand well what you said. It's really useful. For example, in educational projects,
yes,
sometimes there are many people who work outside the university and you hire them for specific time in the project, and that's all what they do in the university.
Yes.
So this
it applies
in
to
this case you do say.
Yes, it applies to part-time work. So somebody on 50% and has, but you cannot cumulate in your organization different contracts for the same employee. That's not possible.
No, you cannot.
So personnel costs, the main method, actual unit costs can be this average personnel costs, or they can be predefined scales by the Commission, in particular for the SME owners, and also, as we said, for the military. So that is the possibilities for personnel costs. What is the standard remuneration? It's the basic salary plus the so-called mandatory extras that are fixed by law or by the employment contract, so which you get because you are the head of the department or because you have some very special skills which are not related to participation in projects, and then this is, we forget all this because it's not applicable to you. And these two define the hourly rate. And now we are in this hourly rate discussion. So the hourly rate is annual personnel costs divided by annual productive hours. The personnel costs come from the payroll, and the annual productive hours. There we have three options. We will see it in a minute. This hourly rate has to be calculated in the organization per financial year. Ex post. So when the financial year is closed, you calculate the hourly rate for each staff member, or if you use average costs for each staff category. When the financial year is not closed for a reporting period, so you have a part of the year for which you have not yet these data, you use the data of the last year. This is different from FP7, because in FP7 you have the possibility to claim next time corrections to this. Now you cannot. So what you report is the final value, always using the last year. This is the example. You have a reporting period of 18 months, which covers part of 2014, 15 and 16. You have the closed financial year here and here, and there are a few months in 2016 where you don't yet have the data, and then you use the hourly rate that you calculated for. Okay, and now what are the annual productive hours? We have a very simple solution. You can use this figure as default and you are safe. No questions will be asked afterwards. If you use the standard 1720, no auditor can come back and challenge you afterwards. Even if your the actual figure in your organization is higher, nothing will happen, because this is defined by law, so to say. This is a standard that we will simply accept. The two others are complicated. They might lead to a bit of optimization of your budget, of the reimbursement that you can get, but they are related to risks. So our recommendation is really go for the standard. So the two options are, you can of course have individual annual productive hours for each staff member, which are calculated by the annual workable hours. That means the number of hours in the contract, saying you have to work 40 hours per week. Oh, sorry. And you add the paid overtime, only the paid overtime, because the unpaid overtime doesn't create costs, it's unpaid. And then you deduct all the absences. Vacation, sickness, training, whatever. And then you have individual annual productive hours for each staff member, and you can use this. If you use this, of course, all these figures will be subject to ex post audit. So you must be ready to document and justify what you have done for each individual person. The third option you can only use if this exists in your organization. So some organizations have standard annual productive hours. So they have definitions in their organization which they use for all their normal billing and internal management. But even there, we have a condition. These standards that you define in the organization cannot be less than 90% of the standard workable hours. This is to avoid abuse. In FD7, we have some companies acting like law firms who charge billable hours. And these billable hours, they are very low. They can be 500 hours per year, because all the rest, these lawyers do something else. And then, of course, the hourly rate becomes astronomical. So to avoid this, for our project, if you have standard annual productive hours, there must be minimum 90% of the standard working hours. Again, the conclusion here, use this.
I hope it is our conclusion as well.
You get some 143 hours per month on average.
Sorry?
The meaning of that is 143 hours more or less per month on average. What I remember is that it's usually more.
Have you deducted holidays, sickness, and everything? If I mean, 143, you have to take into account holidays, public holidays, sickness, and all that, and then it's relatively low.
I think that being simple is a good thing in this case.
Okay. So, some more financial issues. Here, the second part of the slide applies, of course, to you. Your accounts are not in euros. So you do all your accounting, of course, in shekel, and then when you send a financial statement, at that moment you do the calculation using the exchange rate, which is the average exchange rate over the reporting period. So that's the difference to FD7. In FD7 there was we should use the exchange rate on a certain day. Now it's the average over the period. We also think that it's fairer to show, it gives all the variations. Very practically, how do you calculate this? There is a website which makes it very convenient for you. You can slide some rules and you can define a period and you will see the average appearing immediately. So this website is here. One particular issue here, we had, there is the possibility that even you incur costs in euros. So if you rent a hotel in Brussels, you have normally to pay in euros. In the first version of the model grant agreement for Horizon 2020, you had to take these costs in euros and report them directly to us, which is of course completely against the usual accounting practice of any organization. Normally what you do, you incur the costs in euros. When you come home, they are put into your accounting system by transforming them into shekels, and then you put them together with all the rest again in euros. And this is actually the way it will be done. We have just adopted the change of the model grant agreement, so that is the situation as of now. That's the practice. Next subject, receipts. So in a project you can not only have costs, but you can also have income sometimes. And of course, when calculating the EU contribution, this income is taken into account. So because there is a general rule that in a project, by funding the project, you cannot generate a profit. So income must be balanced against the EU contribution. But there are only certain things counting as receipts. This is income generated by the action, but except income generated through exploiting the results of the project. So for instance, because that's the very purpose of the project. So if you, for instance, make a patent in a project and you sell the license to someone, then the income that you generate by selling the license does not count as income. Only other income. For instance, what could happen that you buy a piece of equipment which is then depreciated and you charge part of the cost to the project, and then you sell it before the end of the project, then this is considered as income and it will be balanced against the contribution. In principle, it applies also when you sell it after the end of the project, before the end of the depreciation period. It's very difficult to check.
You can check. And there is no
audit.
Even though.
No, there is no.
5 years up.
No, that is a theoretical matter. You are right, that's a theoretical. But there are other receipts. For instance, when you have in-kind contributions specifically related to the project and received free of charge, which you can easily circumvent by telling the donor, don't make your in-kind contribution specific to the project. Just tell them you get it and use it for what you want, and that's the same for financial contributions. So of course, the general financing of your university by the state does not count as income, because it's a financial contribution which is given without condition to use it in a certain project. But if you have a donor saying, this is a brilliant EU project, I give you $1 million on that project, then it counts as income. If the donor says, you are such a nice university, I give you $1 million, do whatever you want, it's not received. So all these cases are relatively theoretical, but they should be. What happens at the end of the project to actually calculate how much money we are due, or you are due, depending? Of course, first you report all your eligible costs, and then we apply to the eligible costs the reimbursement rate. So So we multiply by 1 or by 0.7, depending on the type of the project. And then we look into the grant, and there is a maximum amount for the grant specified. If the 1 is bigger than the 2, of course the 2 applies. So even if you charge many costs, and all these costs are eligible, you can never go beyond the maximum amount that we are agreed to give in the project. And then we apply this non-profit rule. If the project creates receipts, we have to balance the receipts against the costs and the contribution, and there can be still some reduction. And the last step is there is a possibility of reducing the grant due to the improper implementation or the breach of obligations. So this is kind of, it's not a penalty, but it is we can say we have committed to pay 5 million to this project. You have done some things which you are not supposed to do, and therefore we reduce the maximum to 4.5 million. That is provided now in the model plan. Of course, this has to be very heavily justified from our side, but it's possible. And then if the amount after step 3 is higher than this 4.5 million, we cut it to 4.5 million. So that's the example, you can go through it. Yes?
So this is done after all the periodic financial...
This is for calculating the payment of the so-called balance after the end of the project, together with the finance.
In your presentation,
Yes.
the formula.
Going back?
Yes. When you say, when you include the flat rate, total approved eligible cost.
Yes. Yes. All costs.
All costs,
Including
the
the
overhead.
indirect, yes. Because these are the total eligible
Yes.
costs. Everything. All eligible costs. Yeah. Anything. Yeah.
Good.
So there is no possibility that the grant
Because so something I see, because it should be 125%.
I know. No,
90 and 87.5.
But the logic is different. The
Okay,
logic is different.
so
So
it is
you first
include.
report all your eligible costs, which
There is
include...
can be a misunderstanding.
Okay.
Yeah.
But this is the way we... Yes, okay. So here we have this example. You have a maximum amount fixed in the grant agreement of 200. You had eligible costs of 220. You have a funding rate of 100%. You have 30 receipts, and we decided that you have not behaved correctly, and there is a reduction of 20. So then first you multiply 220 by 1, and then you, of course, arrive here. Then you look at the receipts, and you do this calculation, and you arrive at 190. So you don't arrive at 170, because these receipts are applied to the costs, not to the amount. So we had 220 costs and 30 receipts, so your net costs are 190, so you would still get 190. And then we have to look at this reduction. 200 minus 20 makes 180, which is smaller than 190, so the final amount will be 180. All this is the thing that is done at the end. However, in the normal cases, in 99% of the cases, you normally end at step 2. Because you
Declare 200.
No. You should declare the costs that you actually incurred. But then we maybe cannot reimburse that to 100% because the maximum amount is fixed and can never be changed. Why should you not hesitate to declare more costs? Because when there is an audit and the audit finds some costs ineligible, you might still have enough costs to cover the full reimbursement. So let's say you have...
It's the truth, so you should declare.
Yeah, absolutely.
Yeah.
So let's say in this example, you have declared 220 eligible costs, and we pay you 200 because this is the maximum. And then the auditors come a year later, and they find 5 are actually not eligible. Then you still have 250, and you are still eligible for the 200. So we don't have to recover anything. It's not, there is no ambition to make these two amounts exactly equal. You report the costs that you actually incur. That should be the very basic.
It looks like a clarification of a problem of many years.
Absolutely, yes, yes.
And it sounds fine, which means that you can, as a rule, report more. Actually, whatever you had in doubt, you report, you say. The problem may happen when you as a coordinator usually ask the partners to keep in budget, to respect the budget, and at the end, some who really did that and finally reported a little bit less, say, those who exceeded the budget in terms of cost may benefit from this thing.
Yes.
So it creates a different problem, say, or a problem of behavior in the consultant.
Absolutely, yeah. This is a change of attitude, so to say, from our side, which you should also bring into your consortium.
Yeah.
Yes. Now we are in the nice chapter of controls and audits. So there are some, very few, actually, ex-ante checks. One ex-ante check concerns the financial viability. It does not apply to you because you are public bodies. It applies now only to coordinators, private coordinators, and if the action asks for more than 500,000 euros, then these organizations have to go through this financial viability check. Then we have, yes?
It is project 500,000?
Project.
Or the cost of the coordinator?
Project. Yes. Then we have the certificates on the financial statements, which also count as ex ante because they are before we pay the final amount. So I already mentioned that it's only at the end in Horizon 2020, and even also only if the amount for the beneficiary exceeds these euro 325,000 for costs paid charged on actual and unit cost basis. So the indirect costs are even excluded from this 325,000. And then there is the option to ask for an ex-ante certificate on your methodology for average personnel costs if you use this. You don't have to, you can ask. Then there are, of course, still ex-post audits, but the good news is that the period in which the auditors can come and annoy you is reduced considerably from 5 to 2 years. So after 2 years you are more or less safe for this kind of checks. Of course, any inquiries by our anti-fraud office or any national criminal investigations have no limits. So if there is a suspicion of fraud, of course the authorities can come. But these financial audits that we do on a sampling basis and where you can be hit by chance, they can happen only 2 years after marriage.
What about the Court of Auditors?
The Court of Auditors can come also later.
2 years?
Sorry?
More than 2 years?
They can come
So
later.
they have to keep
I mean, that is an important point.
Thank you.
These 2 years, is not the period in which you have to keep records. You have to keep records according to your national legislation. And in most of the national legislations, this is even beyond 5 years. You, after the 2 years, don't throw away anything. Keep it. It's just for our financial purposes. We have also the notion of extrapolation, meaning extension of the audit findings, meaning if financial audit finds a systemic error in your system, saying one type of cost you always charge too much, then we have the right to extend this finding in one particular project to all the other projects in which you're involved. That happened in FP6 and FP7, it will continue happening in Horizon. But it's now explicitly regulated in Article 1. Consortium agreement. This is something the Commission is not involved in, but still an important thing. You are supposed to have it. We don't check it, but when we come later and we find out you didn't have it, you are in breach of your obligations, and we can reduce the maximum grant amount, as we just did.
Can you request it?
Sorry?
Can you request it? Because we're getting requests from project officers.
We don't have a legally established right to request it, and I would also recommend my colleagues not to ask for it, because as soon as you become implied with it, you take a certain responsibility. So I don't understand this request.
Okay.
And also in which case it was asked.
In health. In all of health projects. The last project, they requested.
You said they don't give any ESR that you can understand something, and they ask more than they should.
You can refuse if you wish.
No,
So look at
we have
what's
it,
going
so
on.
we understand it. We're surprised.
So there is an article saying a few words about this.
In the Commission is called the Texan way of doing it. This is the
I don't. So it's a price agreement between the members of the consortium. It deals with the rights and obligations within the consortium. For instance, all the matters of internal organization, how you distribute new funding, how you settle disputes, how you deal with the intellectual property that was created, and so on. And in principle, it should be concluded before the grant is decided. It can also be a living document. So there are recommendations saying, as soon as you start discussing about a proposal, have a rudimentary version of this agreement with some very basic confidentiality rules, and then you can expand it to more things when you actually get to it. We have, in this annotated order grant agreement, we now have a hyperlink to a general guidance document saying on what the content of consortium agreement can be. And there is also a link to a website which lists some existing models for this consortium agreement. The Commission does not recommend any particular among these models, so you are free to choose one of these models or not to choose any of these models and have your own. That's all under your responsibility. There is just guidance. And then a few words about the intellectual property rights. It has not changed very much compared to FP7. So these basic rules saying that the one who creates the result owns it is of course still there. There is the possibility of joint ownership if it's indeed the work is so intimately interlinked that you cannot distinguish between two. They own it together, but the circumstances are also defined in this model grant agreement. You are supposed to protect your IPR, but this is, so to say, best effort obligation. There are different methods of protecting. One method is keeping it secret, another method is patenting it, and there are other possibilities. And you also have a general obligation, or again, best effort obligation to exploit the results, doing something. either for further research or for actually commercial exploitation. And then there is the obligation to disseminate the results, meaning in normal circumstances you should publish your scientific, publish or patent. You can keep it secret if there is a special reason.
The way it's written, it's maybe it's exploitation or dissemination, exploitation and dissemination.
Yes.
Because if you have only exploitation and no dissemination, it's okay if it's industrial technology.
Yeah, but there is, I mean, one possibility for disseminating is filing a patent, because then you disclose it, but you keep the ownership. So what I said
So
is,
you will put patent on dissemination.
patent is,
So
patent
is
is
also protection.
yeah, it's
protection.
patent serves two purposes at the same time. It protects and it disseminates, because patents are publicly available.
Also, if you want to exploit it and sell it, and you have to speak about it, and it's anyway, you're covered.
Yeah.
Yes, you will have to speak more tomorrow.
Okay. There are some new concepts or reinforced concepts. One is the open access concept. The open access to scientific publications is now standard and obligatory in all projects. You can have the two ways. There is this gold and green. Gold meaning you publish by default at the very start in one of the open access journals, and then at the very start your publication becomes open access. Green means you publish in a normal scientific journal, which is not available free of charge, and then later on you take a copy of this publication and put it into an open access server. All the scientific journals now have these embargo periods, so there is, I think, not anyone anymore saying it's not allowed at all. In many journals, this embargo period is just 6 months, so in all the normal scientific journals. So that means if you publish the green way in a normal scientific journal, after this embargo period, your publication has to appear in an open access server to be accessed by anybody in the world. So that is now a real firm obligation. And then there is an experiment, a pilot project, to also provide open access to research data. So all the underlying data that you create by your experiments and by your explorations. It is currently restricted to some calls in some areas. You see it in the work program if it appears, and you also see it in the proposal submission form whether the option applies. And in both cases, whether it's in the pilot or out of the pilot, you can choose to opt in or opt out. So if your call is in the pilot, you still have the possibility to opt out with a justification. If your call is outside the pilot, you have a voluntary possibility to opt in, but you don't have to. So that's all possible. That will be closely watched and analyzed, and we will see whether this pilot will be extended in the coming years to more calls, and maybe at the end, in the next Paperless program, it will also become a but this is the future. There can be additional dissemination and exploitation obligations if this is specified in the call, the work program. We put a lot of emphasis on the visibility of EU funding, of course. So in all the scientific publication, you need this standard sentence, which is available, and you have to use the EU emblem on all your websites and in the publication when you get funding. As concerns the access rights to the results that you have actually created, you, as the owner of the result, have to give access for implementation and exploitation purposes to all other beneficiaries in your project. So you cannot just say, I created it, I keep it for myself. You are not allowed to do anything with it. Within the consortium, you have to be open. And there is also automatic access rights for the European Union and even for national governments of member states under the Security Societies Charter. This access right means that we can ask for it as the European Union if we think we need it for policy development, implementation of other legislation. It is not that the European Commission takes your new device that you want to market and creates a company and markets it. It's just for these policy purposes.
It has to be justified?
No, this is default, but we are very confined in the things that we can do with that. So as I say, it is for policy development, creating new legislation, not for marketing products.
You have to, if a company doesn't like it, let's say, for several reasons.
They don't accept our funding.
No.
They don't accept.
You have to still justify why you want to receive it, because it's not a general behavior. So you have to explain that it is for policy and so on and so on. Because
yes, but they cannot refuse. So we have a default right to do it. So they, of course, we will in the individual case, we will of course justify it. But nobody can refuse saying I don't want it. That is one of the, so to say, counter measures for the public funding.
on this, if I was in the council, I would discuss on this essential.
Yeah, but the council asked for it.
No, okay.
Yeah.
If I was in the council, I would discuss it. Because I think it's wrong to be in certain matters.
Yeah, but it has never, it was always there, it has never created problems. We are a bit stricter on the transfer and exclusive licensing outside EU and associated countries. So if you want to do this, we might object under certain circumstances. No problem if you do it in Israel, because Israel is now, since a few days, fully associated. But if you want to market something in the US or in China, then there might be. It's not by default forbidden, but we might want to. And then there are tailor-made provisions in some very specific actions, for instance, in the SME instrument and in the so-called fast-track to innovation that will come to be next year. There are some special situations on intellectual property rights. That is nearly the end of this part on the grant agreement. You know that we have a very big document which is called the Annotated Model Grant Agreement, available on the participant portal. Some people even dare printing it out. It is a living document which will change.
Very living. Every month.
It will change all the time, but this is the purpose of it. So it contains all the articles, and under each article, or even sometimes for the big articles broken down in chunks, we put annotations, meaning we try to explain what we actually mean, we try to give the interpretation, we try to give examples, and we try to extend the understanding. And this is indeed a living document, because in the interaction with you, we also learn. We see that there are special cases that have to be treated. Some things are not very well understood, so it becomes a big text. But I think for the ones of you who are managing these grants, you should go there from time to time, and if you have a problem related to a specific article, read through the annotation of this article, and you will find a lot of interpretation. It also serves, of course, internal purposes in the Commission. As I said at the beginning, we are now many actors involved. And this is the unique source of interpretation of these matters. The online manual I already mentioned. And then there is, of course, any type of question you are referred to the Central Research Inquiry Service. Reactions might sometimes be not fast enough in your opinion, but all these questions are in a very orderly process, so there are tickets created, there are correspondents responsible for the different special issues, so sometimes it takes a bit longer, but you can be sure that the question finally arrives at the right place with the person having the competence to reply. Okay, that was the part on the model grant.